Hey, new law students, if you're struggling with knowing how to structure your answers in your assessments and exams, well then this video is for you because I'll be breaking down the IRAC method, which is a very common and simple framework that you should be learning and applying during your legal studies, and also you'll be applying this framework in legal practice. So let's go. So what is IRAC? Well, it's just a simple framework that you can use to help you analyse and structure your answer to a legal problem. So it's a very common framework that many examiners and professors expect us to apply during legal studies. So I've got a simple example on the slide here, and then I'll jump in and show you some more detailed examples from when I applied IRAC into some of my previous papers. So on the slide here, let's just quickly go over the acronym to make sure you're familiar with what each of the letters mean. So I is obviously you need to identify what the legal issue is, and there might be more than one legal issue. Then you move on to R for rules. So that's where you need to identify what are the legal rules that are relevant to the legal issue that you've identified. And then A is for application. So that's where you're going to be applying the legal rules to the facts in the scenario. And then lastly, of course, you're going to be providing a conclusion. So I do have a very short, simple example on the slide here. Now, I haven't provided here the scenario information. I think to illustrate what IRAC is, I thought I'd show you what the written answer looks like. The other reason why I'm not sharing the scenario information is because those scenarios I assume are copyright by the university where I did my studies. And so I really don't want to breach any copyright rules here by sharing information in my videos. All right, so let's just have a quick look at this example here. So you can see here that I've identified the legal issue in the first sentence. So the next issue to determine is whether the police breached requirements to provide the right to contact a support person. And so in this scenario here, Preston is my client and he has been arrested and is classified as a vulnerable person, which I've discussed elsewhere in this paper. And this is just one paragraph of a broader paper. Then for the rules, I've then got that in the second sentence. So under section 123, the protected suspect, and that would be Preston in my scenario, must be provided orally and in writing the right to contact a friend or guardian or lawyer, and also to be able to communicate in privacy. And I've got the footnote there, so that's the legal rule. And now I'm going to apply that legal rule to the facts in my scenario. So Preston was not offered this right until 2:50 in the morning. So because in the scenario, he was arrested the previous evening and he was held. So it was well after 2:50 a.m. in the morning when his interview finished that's when he was given this right to contact a friend, guardian or lawyer. So according to the rule here, when I look at the scenario and the facts in the scenario, poor old Preston, he wasn't given those rights. So my conclusion here for this particular legal issue is that the police breached this provision. All right, so that's a nice short example. Let's now move on and I'll share some more detailed examples. Let's now have a look at a contract law example. Now you'll notice in this example, I actually have headings up here. So we've got the issues heading up here, then we've got the rules heading. And as I scroll down, you'll see I've got the application heading. And as we keep scrolling down, you'll see I then have the conclusion heading. And that format has also been replicated for other questions that we were given in this assignment. But let's just scroll up. What I suggest you do is that for each of your subjects during your legal studies is try and reach out to your lecturers and ask them whether they have a preference for one, Do they have a preference for headings? And you can also ask, well, if they do like to see some headings or signposts, then would they like to see the headings of issues, etc., of the IRAC framework? And you may find that some of your assessors or lecturers, some may say, yes, definitely include those headings in, and other lecturers may say, no, I do not want to see those headings, but they still want to see that IRAC analysis. So just keep that in mind with the examples that I'm sharing today. This is not necessarily the right way to do it, because I found that different lecturers had their own preferences on how they wanted to see your IRAC approach. So just keep that in mind. And again, I'm not sharing the scenario information. I'm just literally showing you the output. And you can see here for this particular question, so I've mentioned that there's more than one legal issue. So we can see here that to determine if there is a valid contract between party A and party B, we must address the following issues. First, was there a valid agreement consisting of a valid offer and acceptance? The next legal issue is, was there an intention between the parties to be legally bound by the terms on the napkin? And lastly, finally, was the agreement sufficiently certain? So, and those different elements you will learn about as you're studying contract law, if it's not making a lot of sense here. But essentially, I've identified 3 legal issues. And that's just one way in which you may be able to explain and write that up in an introductory paragraph. And then I've jumped into the rules. And in this particular example, it's mainly case law. You can see down the bottom here. I've got the footnotes direct to where I've got the rules from. So just for example, a valid contract comprises of an agreement, including a valid offer and acceptance, an intention to create legal relations, an objective degree of certainty and consideration where an exchange of promises occurs. And we can see that's from Byrne and Australian Airlines Limited, 1995, 185 CLR 410, and I've got the pinpoint exactly where that legal rule comes from. And so on. And then you'll see here I've continued to outline the rules that are relevant to those issues. So I'm not going to go through the detail here. I just want to share with you the approach on how I've applied IRAC. So just scrolling down, I continue to share what the legal rules are. And then I've gone into now the application part of IRAC. So I'll just continue scrolling down. And then here where you can see my example of my conclusion. I'll just continue scrolling down. And yes, I've used the same format there. Anyway, so that concludes a really quick walkthrough of a contract law example of applying IRAC. Let's now move on to another example. And moving on to my second example, this is a corporations law subject. Again, we must have received the green light from the lecturer around having headings and also using IRAC as our heading. So as I've mentioned previously, not every lecturer wants to see that, so do check that. But you'll see here in my introductory paragraph, so the first issue to determine is whether JT has breached his duty to avoid a conflict of interest under sections 191 and also 182 to 3 of the Corporations Act, and also fiduciary director obligations in equity. And I'll just go down to the footnote 29, as per the case Aberdeen Railway Company versus Blakey Brothers. So let's just scroll back up. So that's where I've mentioned the first legal issue. The second issue to determine is whether JT acted in good faith in the best interests of CRL under sections 181. And let's just scroll down and you can see that's under the Corporations Act. And fiduciary obligations in equity. So I scroll down, 31, you can see I've got my case authority there. And then the final issue to determine is whether any remedies are available for the CRL Board of Directors. And you'll notice my marker thought that was an okay introduction, so that was nice to see. So then moving on in the paper, I then have the rules section. I've got a subheading for each of those legal issues. So we're still on the rules, but now we're just looking at, well, what are the rules for that legal issue on whether that person breached conflict of interest rules. So this is where I outline some of the rules. I refer to Adler's case as my authority. And just scrolling down, you'll see I then move on to outlining the rules for the next legal issue, so the best interests rules. And then I move into the application part of IRAC. So that's where I'm now applying the rules to the facts in the scenario. And then, of course, a conclusion. So that's another quick example of what a paper might look like after applying the IRAC model. And now moving on to my next example. This particular example is from my equity and trusts subject. So we can see up the top here, I've just got a simple sentence for my introduction. And you'll notice I then have this heading here, issues, rules, and application. But my marker didn't really like me using that heading. I'd like to show you the feedback I received for that heading. Let me just scroll down. And we can see I got 34 out of 40, so it's not too bad. But here we go. So they liked my one sentence intro, but for my heading, it says best avoid rules as a heading. And then in brackets, I know it's IRAC. In law, we do not have rules. We have relevant law and equitable principle. So there we go. So that's proof that it's always a good idea to check with your lecturers for headings. So let me just go right up to the top again. All right, so scrolling down, so I've got here a heading for issue because there's one overarching issue up the top here. So the key issue to determine is whether equity can intervene to set aside Glenn's drink now, pay later contract that he made with his customers under the doctrine of unconscionable conduct. And then the next heading I've got is rules. So rules for the doctrine of unconscionable conduct. So I'll scroll down a bit more. And we can see here that this doctrine, according to the case of Amadio, has more than one limb or more than one element that has to be applied. So let's have a quick look. So to determine if Glenn acted unconscionably, we look to the elements of unconscionable conduct outlined in Amadio. First, the weaker party must show they have a special disadvantage, and we can see I've got my footnotes down here, where they must show one party is at a special disadvantage relative to the other in the relationship. Secondly, the weaker party must show that the stronger party had knowledge of the weaker party's special disadvantage. And then lastly, it must be determined if the stronger party applied willful ignorance of the weaker party's special disadvantage and exploited the weaker party's special disadvantage unconscientiously to obtain agreement to a transaction. And that's come from the case of Kakavas. And also another legal rule, the doctrine of unconscionable conduct to apply, the weaker party cannot rely purely on the claim that the agreement was unfair. Rather, it must prove that the stronger party had a predatory state of mind when the agreement was made, and the elements mentioned above of unconscionable conduct must be shown. All right, so there are my rules for doctrine of unconscionable conduct. Now let's just scroll down. Now you'll see what I've done here is, so here is that first element or that first limb of the test or the legal rule in the case of Amadio. So remember, it talked about a special disadvantage. So let's just go up here. First, the weaker party must show they had a special disadvantage. So that's the first element. So, and that's why I've got a subheading here. So that's the rule. And I then go on to discuss and move in to further details just pertaining to that element. So I've got here, regarding the first element of special disadvantage, Glenn's customers will need to prove that when they signed the contract, they suffered from being at a disadvantage, preventing them from making a good judgment in their own best interests. And then I continue on explaining then how best to determine what constitutes a special disadvantage. And I've made references to other cases to build upon those legal principles and provide some insights. So then we scroll down further. And then this is where I'm trying to move into the application part of the IRAC framework, but only for that element. Okay, so you can see here, this is where now I'm starting to apply the rules to the relevant facts in the scenario. And then as we scroll down, you can see down here is where I've attempted to provide a conclusion statement that's only pertaining to this element. All right, so then moving on, I move to the next element of that test in Amadio, which was the knowledge element. So let's go up to the top again to double check. So here we go. So secondly, the weaker party must show that the stronger party had knowledge of the weaker party's special disadvantage. So that's the knowledge element. So I scroll down and here we go. So now we're just talking about that element. And I say the second element under the doctrine of unconscionable conduct requires Glenn's customers to show that he had knowledge of their special disadvantage. And I've got the pinpoint down there as to where that rule comes from. And then I attempt to move into the application part of the IRAC framework, but only for that element. And then I attempt to apply a conclusion sentence, but again, only for that element. And so you can see here that, and then there's other elements, etc., and I go through the same process. So let me just scroll all the way back down to the bottom. And you'll see down the bottom here, I've got an overarching conclusion paragraph for the whole scenario. So earlier on, I had conclusion statements just relating to a particular element. And then down the bottom here is an overarching conclusion. So there you have it. That's another quick walkthrough of, I suppose, another way to apply IRAC to a written paper. So that concludes this video today. I hope you have a few extra tips now on how to apply the IRAC framework during your legal studies. I'll see you next time.